Okay, welcome everybody. Nice to see some new pictures, some new names. If you've only just registered, welcome. Please, people, if you have only just registered, it is crucial. You're writing your first test in 2 weeks' time. It is absolutely crucial that you listen to the recordings of the classes that you have missed. They are very, very easy to access. What I do is after the class, or a day or so after the class, I download the recording. Then I upload it onto YouTube, onto my YouTube channel. I've started a YouTube channel especially for company law. It's literally called Mariette Hanekom Nast Company Law. So even if you go onto YouTube and you type that into the search box on YouTube, it will take you to my videos. You don't have to do all that effort. All you need to do is go onto e-learning, go to the relevant week. The e-learning platform has been divided into weeks according to the course outline. The course outline is also on e-learning. You should have downloaded your course outline by now, and please read the whole document. There's important information in there. Then you look at which week you're looking for, and then you go on to click on the link that takes you to the relevant week, and you will see I have uploaded the URLs for the recordings. So you click on the URL while you're on the e-learning site, and it takes you straight to the recording on YouTube. As easy as that. No searching around, no struggling. You have to listen to these recordings, people. It's extremely important if you have been missing classes. Even if you haven't missed classes, I would recommend you go and listen to them again when you start preparing for your first assessment. Okay, so tonight we have a very short unit. We're slightly ahead of schedule. We were only supposed to do Unit 5 this week, which I completed the whole of Unit 5 on Tuesday. We don't do Unit 6 at all. Unit 6 is out. By the way, I've also had hard copies of the study guide printed. They are available from the printers. So,
Hi, ma'am.
Yes.
Ma'am, how do we get the study guides? Are we buying them from anywhere or?
I have had hard copies printed. They are available from the printers on the NUST Upper Campus from Nashua. Don't know what they cost, but it's not very much. Alternatively, if you don't want to buy a hard copy of the study guide, you can go to e-learning. The entire study guide is also on e-learning. All the units separately under the heading study guide. Also, like I've just explained, they're different weeks. So if you click on what week are we at the moment, I think this is week 3. Let me just check that for you. Yes, we're at week 3. So if you click on week 3, you will find the study units for week 3. You will find my PowerPoint slides for week 3, as well as the links, the URL to the recorded lecture. So it's all there for you. You just need to go onto the e-learning site. E-learning site is fully updated. It looks neat, everything. If you are not enrolled for e-learning, you can use the self-enrollment code. Self-enrollment code for e-learning is the course code CLP 512S. And if you really battle to get yourself enrolled on e-learning, please send me a message on WhatsApp. But don't ask me, please, people, don't ask me on the group to enroll you for somewhere, because then I get so many messages on the group and I lose track of them. If you want me to enroll you somewhere, please send me a private message and then I will assist you. I have also shared the link to the WhatsApp team on the group twice today already. Click on that link, ask to join the group, and it sends a request to me, which I will then from time to time, I don't approve them as they come through, but every so often I will go in and then I just approve you joining the group. Okay, any further questions?
Not from my side, ma'am. Thank you.
Okay, while I'm sharing my screen, is everybody with me? Has everybody kept up? I know there are some people that only joined today, but those that have been part of the class since the beginning, are you with me? Are you keeping up with the work?
Yes, ma'am.
Wonderful. Please, if you have any questions, ask them on the WhatsApp group. Don't get left behind, please, 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 people. Company law is a very complex subject. Okay, can you see? Just give me a thumbs up. Can you see the slides? I've shared my screen. Can you see the slides? Sydney can see them. The rest of you? It's only Sydney that's reacting. Just give me a thumbs up. Chantal, can you see the slides? Okay, so unit 7. Unit 7 is a very short unit, so you'll be pleased to hear that we'll be finishing a little bit earlier tonight, but I did want to get Unit 7 out of the way. Unit 7 is about internal relations. Just a reminder, while I'm teaching, I'm got the screen with the slides open in front of me, so I cannot see you. So if you have questions, please speak up, or otherwise just type them in the chat box. But you're welcome to just interrupt me and ask your questions. Okay, so internal relations. How do relationships within a company work? So what we're going to do in the next few weeks is tonight I'll briefly explain how relationships work within a company, specifically between the board of directors on the one hand and the shareholders on the other hand. Then next week, we look at how do shareholders function, how do they make decisions, and then the week after that, we will look at directors. How do directors, how are they appointed, etc., etc., etc. So just the overview then today, Unit 7, Internal Relations. Now, okay, your learning objectives there, what is an organ of a company, the most important organs, etc., etc., etc. Remember, as I always say, once you have gone through the unit, go back to your learning objectives and make sure that you can address all of them. Now, a company, okay, let's go one step back. Let's go back to Unit 2. In Unit 2, when I was starting to explain to you what a company is. I pointed out to you that a distinctive feature of a company, as opposed to, for example, a close corporation, a distinctive feature of a company is the separation between ownership and control. Ownership and management. Let's rather use the words ownership and management. You have the shareholders who are the owners of the company. And then you have the board of directors who manage the company. So they manage the property of the shareholders. Before I go on any further, let's stop at this and clarify some common confusions that arise. First of all, the Companies Act says that every company must have a board of directors. You cannot have a company, like you cannot have a company with shareholders, you cannot have a company with a board of directors. By law, you need both. The Companies Act, I also mentioned this in a previous lecture, is primarily written from the point of view of public companies. And then it makes exceptions for private companies. Students often get confused when I say there's a separation between ownership and management, because they then seem to interpret this as I'm saying that the shareholders may not be directors, or the directors may not be shareholders. Now, that is absolutely not true. In your smaller private companies, your shareholders, more often than not, are also your directors, which means you have one person that is involved in the company in more than one capacity. And you must always distinguish when you're referring to this person, in what capacity are they? Are they in their capacity as shareholder or their capacity as director? Just to give you an example so that you can properly understand why it's actually silly to reason that shareholders may not be directors. Let's say Sydney and Tangeni have a business idea. So they decide to register a company in order to try to make money out of this business idea. Why do they register a company? Because of the protection of the juristic person, so that they won't be personally liable for the debts. They decided on a partnership. They're also allowed to do that, but then ultimately they can be held personally liable for the debts. So they don't want that. So they register a company. But this is Sydney and Tangeni's business idea. They want to run the business. So when I say there's a separation between shareholders and management, shareholders and the board of directors, I am not saying that Sydney and Tangeni as shareholders must now appoint Chantel and Florence as the directors to run the business and do the business for them. That would just be silly. Can you understand how silly that would be? That it's their business idea, but now they're not allowed to do the business because there must be directors that manage the company. Of course not. Doesn't make sense. So Sydney and Tangeni will be the shareholders and the directors. But when you get a public company that has got 100 shareholders, your common sense should also tell you that those 100 shareholders cannot all be involved in running the company. So the shareholders will then appoint a board of directors, typically consisting, depending on the size of the company, of about 3 to 7 directors that will be in charge. And the rest are just shareholders. But now I've said the rest are just shareholders. Doesn't mean they play no role. I'm going to clarify that later. So, in a company, you have a lot of people that are involved. You have your shareholders, you have your board of directors, and then you have employees, like a company secretary, the accountants, blah, 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 blah. Lots of people are involved in a company, especially if it's a bigger company. To ensure the success of the business, there will be a lot of people involved. Now, yes?
Sorry, miss. I just joined late. Which chapter are we now?
We are doing Unit 7 this evening.
Okay, thank you, miss.
Okay. But when we look at everybody that is involved in a company, you need to distinguish the first distinction that you have to make. And I'm just quickly, because the word terminology isn't here, I'm going to put it in the chat box. People that are involved in a company are referred to as functionaries. They fulfill a function. They have a job. But now you need to distinguish between the functionaries, people that just do a job, and the organs of a company. This brings us to our first slide, the organs of the company. The organs of the company is the board of directors acting together as a board, not individual directors, but the board acting as a board, and the members or shareholders acting together. The term that we use for that is members in general meeting. So shareholders not acting as individuals, but acting as a collective. These are the two organs of the company. I like to describe them as the brains and the heart of the company. And the functionaries are the legs. So if you look at a human being, there's a brain and there's a heart. Then there's arms and legs and ears and a mouth and whatever. A company can exist, a human being can exist without an arm. They can have a productive life without an arm. They can have a productive life without a leg. Functionaries are not indispensable. But a human being cannot exist without a brain and a heart. If your brain doesn't work anymore, you're dead. If your heart doesn't work anymore, you're dead. So the board of directors and the members in general meeting, the two organs of the company, is like the head, the brain, and the heart of the company. Company cannot exist without them. Now, as I've already said, Companies Act says that a company must a company must appoint a board of directors to manage the company. The central question that we're looking at Unit 7 is this one there at the bottom of the slide. Namely, the question of who is the boss? Can the shareholders, can the members in general meeting instruct the directors how they should manage the company? Let's get some opinions on this. If you were a shareholder and not a director, can you instruct the directors of how to manage the company?
Ma'am,
Yes,
if I
Chantal?
was a shareholder but I'm part of the board of directors, is does that still count for your question?
Um, that's a good insight. If you're a shareholder and also part of the board of directors, then of course, as a director, you're involved in the management decision making. I was more referring to instances in a public company, for example, where there are shareholders that are not directors.
No,
In a,
ma'am, then I
yeah,
think the answer
in,
is no. That those shareholders who are not part of the board of directors, they won't be able to make the decisions because the board of directors are whom are also shareholders will are the ones who will make the decisions on how the company should be run. But the other shareholders who aren't part of the board of directors, I don't think they play a part in making decisions.
thank you, Chantal. You can take over the class. Torian, Mr. Mapenzi, what did you want to say?
Just maybe in addition to that, it doesn't look good for shareholders to give instructions to directors because it means they do not have their independence in terms of exercising their duties, which is assigned to them.
Very, very important word that you've mentioned there, Mr. Mapenzi. Independence. The board is independent. Sydney, your hand is also up.
Ma'am, I think the shareholders, they don't have a say on the day-to-day management of a company, although um, it may be stated that, how can I put it? Um, Although the articles sometimes in the founding statement of the company, the powers of directors can be sometimes be, I cannot, how can I put it, can be there's sometimes where the shareholders can instruct the directors on a certain instruction or something like that, if I'm not mistaken.
Okay, Sydney, all three of you, Chantal, Mr. Mapenzi, and Sydney, all three of you are correct. I'm loving this insight that I'm getting. Just a bit of terminology, Sydney, just to remind you, don't refer to the founding statement. Companies don't have founding statements. It's the articles, the constitution.
Yes,
So
yes,
just,
ma'am.
yeah, yeah.
Founding statement is in a CC, it's not in a company.
Is in a
Apologies.
CC, absolutely. But we're busy with companies, so just make sure that, because you seem to have the understanding, don't throw away unnecessary marks by getting your terminology wrong. Just watch out for that.
100%, ma'am.
Yeah. Okay. But all three of you are absolutely correct. The question is, let's go back to my slides. Can the members in general meeting instruct directors how they should manage the company? The answer to that is a very short, sweet, and simple no. No is also a full sentence. So how does it work? Let's take you back. I told you companies are very, very old. A quote here, you don't need to memorize this quote, but it illustrates how things work. The John Shaw case, John Shaw and Sons versus Peter and John Shaw, dating back to 1935, so it's almost 100 years ago. The This is one of the important foundational cases of modern company law, where it was said in the judgment that the general body of shareholders cannot usurp means take over. The general body of shareholders cannot take over the powers which by the articles are vested in directors, any more than the directors can take over the powers vested in the articles in the general body of shareholders. What this boils down to is the balance of power between shareholders and directors will be determined by whatever is stated in the Articles of Association, in the Constitution. Sydney said, but he used the wrong word there, but I didn't want to point it out there because he wasn't quite right. He said that the Constitution, in the Constitution, the shareholders can retain some powers of management powers to instruct the directors. No, they cannot. They can never instruct the directors. What they can do is they can, in the Constitution, retain for themselves as a collective of shareholders certain powers of approval. Can you see the difference? There's a difference between instructing the directors and the directors making a management decision, but the shareholders have to approve it first. Do you understand the difference? Can you see the difference there?
Yes, ma'am.
There's a difference between me telling Tangeni what to do, giving him an instruction, and Tangeni coming to me and saying, I want to do this, may I? Shareholders can, in the Constitution, retain for themselves certain powers of approval. For example, if the directors want to sell the fixed property of the company, the shareholders have to approve the sale. Or if they want to go into a transaction in excess of $1 million, the shareholders have to approve it first. There's a difference between having power of approval. There's a difference between the shareholders telling the directors, sell the building. They may not do that. But if they have power of approval, the directors can decide in their management capacity, we want to sell the building. But the articles say we need shareholder approval first, so we must call a general meeting and follow the procedures to get that approval. So whatever is set out in the Constitution will determine to what extent shareholders can exercise approval, can limit the unlimited management powers of the board of directors. But from a practical business point of view, it will not make sense for shareholders to want to retain too much power for themselves. Companies Act says there must be a board of directors that will manage the company. Shareholders can withhold power of approval that can, to a certain extent, limit their management powers. But it wouldn't make sense to be too strict. Shareholders having in the Constitution that every decision by the board of directors must first be approved by the shareholders. The company is not going to get anywhere. Shareholders meetings take a long time to call. There's 14 days notice required. Next unit, we look at how meetings are run. So For shareholders to want to have so much power to say that every management decision must be approved by the shareholders first. Now the directors want to buy stationery and you have to give 2 weeks notice for a shareholder meeting to approve them buying stationery. You're all intelligent human beings. You can see that that would make absolutely no sense. The company would get nowhere. So yes, shareholders can in the constitution retain a certain amount of power of approval for themselves, but from a commercial point of view, it would not make sense to try to limit the management powers of the directors too much. The bottom line is that actually who's the boss is the articles of association. Shareholders cannot override, the second bullet point. Even a unanimous, the word unanimous means, you know what it means, everybody. Even a unanimous resolution of the general meeting does not override the director's powers. So even if all the shareholders decide we don't want the directors to do that, they can't, because this is part of the director's powers. Matters that fall within the exclusive jurisdiction of the directors and the general meeting respectively are determined by the articles. But now what happens if the shareholders are really, really, really unhappy with how the directors are managing their company? Must they just sit back and keep quiet because the Companies Act says there must be directors? No. Ultimately, the shareholders still have control of the directors because they can fire them. Companies Act, we get to this in Unit 9. Companies Act provides for a procedure in terms of which shareholders can remove the directors. So if the shareholders aren't happy with the directors, they can fire them. But, and now it's like a snowball effect or a circle effect, the moment they cannot fire them and not reappoint, the moment they fire them, they have to appoint new directors that will have the same independent powers. And then just that last bullet point there, what I've already discussed just now, it's not feasible to place too many restraints on the powers of the board. The board is designed to manage the affairs of the company. They need their independence. Shareholders cannot and should not try to interfere too much, to have too much, to retain too much powers for themselves. Companies Act, however, does provide for 3 instances where the shareholders acting as a collective in general meeting may intervene and temporarily take over the functions of the board. That is first instance where legal action needs to be instituted. Legal action, going to court, is a management function. If there was something wrong and the shareholders feel that legal action needs to be instituted, but the board of directors is refusing to do this. Typical example of this would be if it's the directors that themselves that have been involved in funny business and the shareholders realize that and want to take them to court. And the directors aren't going to institute action against themselves. Then the Companies Act provides procedures to be followed where the shareholders may do so. In instances where the board of directors cannot or will not exercise their powers, for example, if there's a deadlock, they can't make a decision because 3 say yes and 3 say no. It's unlikely for that ever to happen in reality. because the practice is for boards, for companies to appoint an uneven number of shareholders. So rather than 6, they will appoint 7, precisely to avoid the situation where 3 are saying yes and 3 are saying no. Or the last instance, where the board of directors have done something which can be set aside, which is voidable because they exceeded or abused their powers. So if they were supposed to get shareholders' consent before doing something and didn't do that, so they exceeded their power, they abused their power, shareholders can intervene to set that action aside. But otherwise, as you all said when I was asking questions, I didn't even have to teach you this unit, because when I asked you the basic question that we were going to address in this unit, you all had the answers ready. Wonderful. I'm proud of you people. I'm liking your insight. Questions about this? Is very, very, very short unit. I told you it's going to be short, so you can still have some family time this evening, spend some time with your families. Any last questions?
No questions, ma'am.
Mr. Mapenzi, your hand is up.
Just one question.
Yes.
We discussed a little bit about internal relations, which speaks more to shareholders and directors. So I've seen a case where Bank of Namibia have intervened into a company. Do we call that external relations?
That would be external, yes. But the Bank of Namibia's intervention, I'm guessing this was either a banking institution or something like that. The Bank of Namibia has got certain powers to intervene, which they derive from the Banking Act, the Financial Institutions Act. I'm not quite sure of the correct name. So that isn't quite what we were talking about tonight, because that would be external. The Bank of Namibia is an external entity which then steps in order to, if they feel it's necessary, to protect investors, shareholders, clients, whatever. So that would be external, yes. Mr. Petrus, your hand is also up.
Yes, good evening, ma'am.
Good evening.
I think I just have a question or a comment. I think I've seen somewhere where it says independent board of directors and non-independent board of directors.
Yes, Mr. Petrus, we will get back to that in more. Good question. Thank you for asking. We will get back to that when we do Unit 9. The difference being, and this, it relates to corporate governance. And the King Code and the NAM Code of Corporate Governance, we don't unfortunately do that unit in detail, but you will also come across that later in your studies when you do auditing. But the principles of corporate governance, specifically with a public company, requires that a public company must have a certain number of independent directors. The terminology that we use is executive director. An executive director is also an employee. An independent director or a non-executive director is not an employee of the company. Just a random example, for quite so many years, I served as a non-executive director on the board of directors of the Roads Authority. but I was working for the Polytechnic or NUST at the time. I was never employed by the Roads Authority. I just served on the board of directors. You attend meetings every so often. You don't earn you get a sitting allowance. You get paid for attending meetings, but you don't earn a monthly salary from them. The importance, Mr. Petrus, of independent directors is that independent directors, if they see things are being done in a wrong manner in the company, they will be more inclined to speak up and express their opinion because they're not going to get fired. A director who is also an employee might decide, okay, I see things are being done incorrectly, but I'm just going to shut up because I don't want to lose my job. We'll get back to that in Unit 9. We'll talk about that again. So yes, the board of directors itself is independent from the shareholders, although the shareholders can remove them. But it is also important from corporate governance to make sure things happen in the correct, in an ethical manner, that there must be a certain number of directors that are totally independent, that just have a supervisory role to make sure that business is conducted in a proper manner. Sydney, your hand is up again.
Sorry, ma'am. Just some clarity. Okay, the main organs is, as per today's lesson, is uh, the board of directors and the shareholders. Is there a difference between the board of directors and the board of commissioners in
The
terms
board
of
of, sorry, I didn't,
commissioners? The board of
I didn't,
commissioners. Can
I'm
you hear
not,
me?
I'm not quite sure what you mean by board of commissioners. Is that what you said?
I read something, I think in last week, it was an article about there is like in, what was the thing, where they state that the main organs of a company, of course, is the shareholders and but they did mention also that there is a board of commissioners. But I just want to know, is there a difference between the board of directors and the board of commissioners? Because I cannot remember exactly what is the issue, because it was also a sort of a interaction in a board meeting regarding taking shares or something like that and making a decision on a specific thing. But it was more of that the board of commissioners said the most or was most affected by the decision or something like that. But I'm not sure. But I just wanted to confirm: is there a difference
Yeah,
between the two
Sydney,
groups?
This to be angry.
okay, Ms. Hama says, can you just switch your, uh, just mute your mic, please, Ms. Hama says. You're chatting to somebody in the background. Sydney, a board of commissioners is not a company law terminology. That's why I'm battling to understand what you mean.
Okay.
If you could perhaps see if you can locate this article that you read again, and send it to me so that I can look at it and see exactly what was referred to. Because no, generally speaking, companies don't have a board of commissioners. They have shareholders and a board of directors.
Okay.
It could
I will
be
try
that
to
it
do
was,
that, ma'am, and just forward it to you.
please, I'd be very, very interesting, and then we can have a discussion about it. It
Yes,
could
ma'am.
be that it wasn't a company specifically, but some other type of juristic person.
Ma'am,
Yeah,
I have seen that. I just wanted to add on Sydney. I have seen that terminology, but I don't know in what sense is it used, but I have seen that.
the term itself can be used. For example, the SSC, the Social Security Commission, doesn't have directors. They have, the Social Security Commission has a board of commissioners. People that serve on their governing body are referred to as commissioners, not as directors. But they do the same job as directors would do in a straightforward company. So it could be that is where this comes from, that the article that you and Sydney read didn't specifically refer to a typical company. Social Security Commission is also a juristic person, but they are governed by a board of commissioners. But a company, an ordinary private company, doesn't have a board of directors and a board of commissioners. Commissioner is just really a different terminology which is used within a particular context to refer to the governing body. So I think that is where the confusion possibly arose. But if you can look around, please, Aronesia and Sydney, both of you, if you can find this article you were referring to, please send it to me, and then I'd love to read it and give you feedback, and we can have a discussion on that.
Okay, we'll do
ma'am.
that, ma'am.
Okay, great, people. I'm really enjoying you. I'm liking the fact that you think a little bit further than just the study notes. I really pity my colleagues that are teaching the first year students, the school leavers. They are really battling with the subject because these poor children have literally, they don't know how the world works. They are clueless. They are really battling with the subject because they just don't. They've literally never heard of a company before. And now we're talking about directors and shareholders. At least you people have got real life experience. Read your newspapers, read the business section of the newspaper. If there's anything there that you don't understand, please ask me. Company law is a real life subject. This is what is happening out there every day. So it becomes interesting if you start reading newspapers and you see, but hang on, that's what we discussed in class. So thank you very, very much. I will see you next week then. Have a wonderful weekend.
Thank you, ma'am. Thank you.
Thank you, ma'am.
Thank you. Thank you, ma'am.
Bye.
Bye.
Bye,
Thank
ma'am.
you.